Mr. Chairman.
Good choice.
Chairman, being back for the first time in 3 years, I was astounded to have to speak on a bill that takes away the rights of good, hard-working Kiwis. You know, the first speech I heard was the Prime Minister's speech from the throne, which set out these lofty ambitions around child poverty, housing and all these other great things. The first piece of legislation before the House is a piece of legislation that takes the rights from good, hard-working Kiwis. There's a little bit of dichotomy there, I think. Mr. Speaker, what I would like to speak about is Part 1, Section 4, Clause 1B(a), and this talks about the disclosure of information, and I quote here, "This subsection does not require an employer to provide access to confidential information." And what it does, Mr. Chairman, is it sets out a list of conditions under which an employer does not have to provide confidential information to an employee. Now, personally, I actually think that this offends the principle of natural justice, and that is actually a right to a fair hearing. But Mr. Chairman, let me give the other side the reason why we have this bill before us, and especially this clause before us, because it sets it out right here in the regulatory impact statement. Let me quote. This is about, Mr. Chair, this arose from a case between the Vice-Chancellor of Massey University and Wrigley 2010. It's quite a well-known case in the Employment Court. It set a number of precedents. It's the only case on this, and let me tell you what the RIS says, and I quote, "The judgment is not consistent with widespread, desirable and accepted employer practices in restructuring and redundancy situations." Mr. Chairman, this is very definitely about what is good for the employer, how they can make workers redundant without going through the practices of fair and reasonable consultation. It says it here in black and white. And do you know what, Mr. Chair? It actually says, when it looks at the scope of this problem, it actually says there is limited information on the scale of this problem. It actually admits they don't know what the problem is. There is one case. And Mr. Chairman, I'll tell you one other thing the Select Committee did. They had a look at a range of options on how to deal with this. And one of them, they said, is status quo. And what they said under that is benefits of the status quo include time to monitor the impacts of the decision and see how employer practices develop. You know what, Mr. Chair? They decided not to do that. And I suspect the Attorney General over there, who is a very good lawyer and is renowned in legal circles, has great difficulty with this. Because, Mr. Chairman, what this is it's a reaction to one piece or to one decision in the Employment Court without seeing how this beds down, without seeing how the market handles this. They're saying, no, we don't like that decision, we're going to change the law. And, Mr. Chairman, that is not a good way to change the law. That is not good legal practice. And I'm astounded, Mr. Chairman, that the Attorney General hasn't just tapped Mr. Bennett on the shoulder and said, "Excuse me, Mr. Chair of that Select Committee, I don't think this is the right thing to do. Let's give this a little bit of time and let's see how the market reacts." The other thing, Mr. Chair, that surprises me is it says in the regulatory impact statement, when it talks about the status quo, these legislative requirements differ significantly from common understood principles of information provision to employees, particularly during restructuring and redundancy situations. But, Mr. Chair, I would argue that that is a contradiction of the clause above it, when it said they don't even know the scale of the problem. So what are we actually trying to address here? One situation, Mr. Chairman, one situation. And so let's have a look at the legislation. Section 4, Clause 1B, Part A. This is not requiring the employer to provide access to confidential information that is about an identifiable individual other than the affected employee. Now, keeping in mind, Mr. Chair, a lot of this is about restructuring and making employees redundant. So there's a whole lot of legal precedent around how you can actually do this. And a number of the legal precedents, and the Attorney General will be well aware of these, you know, the Communication and Energy Workers Union and Telecom New Zealand Limited and Wellington International Airport and Air New Zealand Limited, these set out a number of tests around the definition of consultation. And, Mr. Chair, a number of these tests are very important to what actually constitutes fair and reasonable, Mr Chair,
Stuart Nash.
thank you, to what actually constitutes fair and reasonable behaviour. Now, as the clause I read out, that is about an identifiable individual other than the infected employee. And, Mr Chair, the thing that really sets off alarm bells for me about this is with the non-disclosure of information, a bad employer, and most employers are good employers. I want to put that on the table. But a bad employer could say to an employee, I'm not going to tell you, Mr Employee, why I'm firing you, because they've changed the law and I don't have to disclose that information. And, Mr Chairman, I think that is a real breach of the duty to act fairly. I'm reading the bill, Mr Bennett. I'm reading the bill here. I actually read it out. The other thing here, if we go down to clause E, where it is necessary for any other good reason to make, this is where an employer does not have to disclose information, where it is necessary for any other good reason to maintain the confidentiality of information, for example, to avoid unreasonable prejudice to the employer's commercial situation. Now, again, Mr Chairman, there is a number of legal precedents around this. What determines unreasonable prejudice? And I think, Mr Chairman, what is going to end up happening is this is going to have to be determined by jurisprudence, because this is just not clear. I can imagine an employer would say, I don't have to disclose that information why I am making you redundant, because it is, quote, unreasonable prejudice. But the problem we've got here, Mr Chairman, as I see it, is there are a number of very clear tests that have been set out by the Employment Court around how an employer must deal with an employee during a restructuring situation. They are very clear, because what has happened in the past, Mr Chairman, is employees have not been treated well, and the Employment Court has now set out a number of tests which allow the employee to have access to natural justice. And I can imagine, as I mentioned, that this would allow an employer to be very disingenuous in the way they communicated with that employee. And I have grave concerns. But the other concern I really have is because the tests that are set out now around restructuring, and certainly in terms of redundancy, are quite clear, it makes it quite easy for an employee who feels aggrieved to actually take a case to the Employment Court and get a fair hearing in a personal grievance. And the reason I say that, Mr Chairman, is it's actually very expensive for an employee to take a case to the Employment Court. Luckily, if an employee is in a union, then the union has the ability to do that. And what you find in a lot of these cases before the Employment Court is it's actually unions who are taking an employer to the Employment Court, because they are the only ones who can afford to do it. But under this, it just creates a whole level of uncertainty that Employment Court precedents actually got rid of. So what we ended up with is a situation which was actually very fair and reasonable. It really was fair and reasonable. It meant the employer had to consult, and there's a whole lot of jurisprudence and a whole lot of precedents around the level of consultation, what it meant, how it was to be undertaken, and basically good faith, natural justice. And we all understand natural justice. What this does, and I am really concerned about this, is it once again blurs the line. What it does is it moves the pendulum far too far over to the right when we had settled quite well in the centre. And I think a lot of us will agree, maybe 60 years ago the pendulum was too far to the left. But a lot of jurisprudence and a lot of really good decisions by Justice Travis, for example, brought it right back to the centre. So employers knew their exact obligations. They knew their obligations. And Mr. Attorney General, I hope you're going to stand up, because I don't know how you can defend a piece of legislation that is made to repeal one decision that was made in the Employment Court. It really is not a good way to make law. But, Mr. Chair, I'd like to reiterate, this is not about the workers versus the employees. This is not about employers versus unions. This is not about us versus them. All this is about, Mr. Chairman, is a fair go. And Part 1 for subsection 1B downwards takes away the ability of the employee to know exactly where they stand. The other thing also, and Part A, as I said, about an identifiable individual other than the infected employee. What is to stop an employer saying to Mrs. King, I'm going to make you redundant because of what someone said. Well, who said what? I'm sorry, I cannot tell you that.
I call the honourable member Simon O'Connor.
Thank you very much, Mr Chair, for this call. Look, there's a couple of things need to engage, firstly, from that member. He's saying that it's all about